All rise.
Thank you. You may be seated. We're here today in a case of Dignity Health versus Farmers Insurance Company of Arizona. It's our case number CACV180292. This is the time set for oral argument. Each side will have 20 minutes. Counsel for appellant, you're responsible for reserving any time you might wish to have for rebuttal. These proceedings are being audio and video recorded, so we would ask that you identify yourself and your client the first time you approach the podium. We have read the briefs. We're familiar with the record in this case. We've conferenced the matter this morning. And with that, counsel, you may begin.
Thank you and good morning. Christopher Herring on behalf of Appellant Dignity Health, and with me at counsel table is Richard Burnham, who is also on our briefing. I think this is as simple and as straightforward of an appeal as you're probably likely to see here, in that there is only a single question of statutory construction that's before you this morning, and it's this. Is MedPay coverage excluded from the scope of a healthcare provider's lien under ARS 33-931? And we would submit that the answer to that question is clearly no, that MedPay coverage is not excluded from the scope of a healthcare provider's lien, and that the trial court erred in concluding to the contrary. I'd like to make three primary points while I'm up here. First, the legislature has not excluded medical payments coverage from the scope of a healthcare provider's lien. If you look at the lien statute, 33-931, the lien granted by the legislature in favor of healthcare providers is quite broad. It extends to all claims of liability or indemnity for damages arising out of the particular accident for which the patient received treatment at a medical facility. There are only two exceptions the legislature has enumerated to that statute. First, for health insurance, and second, for uninsured and underinsured motorist coverage as defined in ARS 20-259.01. Those are the only two exceptions the legislature has crafted in this statute. And what that tells you, Your Honors, is that the legislature knows how to exclude particular claims and lines of insurance coverage from the scope of a lien if that is its intent to do so. But equally important is that the legislature also knows how to refer to MedPay coverage when that's its intent. I've been using the term MedPay up here, and our brief uses the term MedPay, but what MedPay really is, when you turn to the insurance code in Title 20 of the Arizona Revised Statutes, is it's sort of a term of art, medical payments coverage. And when the legislature seeks to refer to this coverage, whether in regulating it or whatever the case might be, the legislature uses that term, medical payments coverage. And you'll see at least a couple uses of this term in Title 20. So let's assume the legislature had intended to exclude MedPay coverage from the scope of a lien as Farmers is contending. The legislature would have had a quite simple way to do that. The legislature could have simply added an exclusion for medical payments coverage to the scope of the statute, or to the exclusionary clause of the statute. So the clause would read, healthcare providers get or have a lien on all claims of liability or indemnity except for health insurance, medical payments coverage, or UM/UIM coverage under 20-259.01.
But presumably, alternatively, 2259.01 could define health insurance somehow. If we're reading, as Farmers is reading it, to mean that health insurance as defined in Section 2259.01.
Yeah, and I'll address Farmers' construction of health insurance motorist coverage momentarily, but yes, in theory, the legislature could do that. The legislature could, and frankly, the legislature could also have defined health insurance in 33-931 itself to include MedPay coverage.
But you're reading 33-931 as if it said except 1, parentheses, health insurance, and 2, underinsured and uninsured motorist coverage as defined in.
Yes, that's correct. And as our briefing, I think, walks you through, and I'll get to in a little more detail momentarily, the mistake Farmers is making here is severing uninsured and underinsured from motorist coverage in the phrase uninsured and underinsured motorist coverage as defined in 20-25901. That's the error that we see in Farmers' position here. But to return, I think what the had the legislature actually intended to exclude MedPay from the scope of a lien, the legislature would have done that. And the fact that they did not do that, using the terms medical payments coverage or something similarly clear, as you pointed out, Judge Catani, that means, and I think that compels a conclusion, that the legislature has not excluded MedPay coverage from this lien, and that the hospital does have a lien on claims involving MedPay coverage. And the trial court mistakenly basically grafted an exception onto the statute for medical payments coverage and added this third exception. We think that's enough ultimately for the court to conclude that the legislature has not excluded MedPay from the scope of a lien. But I want to walk through first why the trial court's decision here was wrong, and then I get to the other argument Farmers is making up here on appeal. At the trial court, Farmers argued to the court that MedPay is health insurance, so it's within the first exception in the statute. Interestingly, Farmers does not argue this on appeal, even though the trial court agreed with Farmers. Farmers doesn't argue this on appeal. Farmers is not arguing that MedPay coverage is health insurance. Farmers is arguing that they've created this new exception called health insurance motorist coverage that I'll get to in just a moment. So I think, I realize we're on de novo review. I don't know how meaningful this is, but I think you can conclude Farmers has confessed error on this point. But again, we're on de novo review. So
let me ask you, even if confession error didn't apply, how would the concept of waiver apply to that?
Well, the concept of waiver, I don't think would apply to the argument about that MedPay is health insurance. I think it argues to the health insurance motorist coverage argument being asserted up here on appeal.
Well, the reason why I ask that is typically I think our cases say if a party argues, say, A in Superior Court and then does not press that argument on appeal, that's a waiver.
I guess, maybe I'm parsing too fine of a distinction, but I think you call it waiver or confession of error, I think you get to essentially the same spot. If the trial court,
can't we affirm though on grounds other than if we can affirm based on grounds other than what the court reached, would that necessarily be a waiver if it's couldn't we just affirm if we thought the court got it right? Notwithstanding an argument not raised on appeal?
In this situation, because we are on de novo review, I think you can. If the court finds that what the court's ultimately doing is construing what 33-931 means, and if the court let's say the court's inclined to agree with Farmers' health insurance motorist coverage theory, we would argue that that's been waived on appeal. But I also see the idea in the argument that since we are doing a de novo review, this is a statutory construction issue, I can understand that position. So to be very clear, there's no facts at issue in here. This is, we're here on dismissal from Rule 12B. And so, but the point I'm ultimately going to make about health insurance motorist coverage is that it is actually a different argument than arguing that MedPay is health insurance. They're actually two different things Farmers is arguing here.
Right, and as to the latter argument, was that pressed before the Superior Court?
No, Farmers did not argue before the Superior Court that MedPay was health insurance motorist coverage. Farmers argued before the Superior Court that MedPay was health insurance. And so it fit into the sort of self-contained exclusion in the first prong of the clause. What Farmers did not sort of split up UMUIM as, UMUIM motorist coverage as defined by 20-25901. Farmers did not do that before the trial court. I do want to return, though, to the point that the trial court did incorrectly agree with Farmers that MedPay was health insurance. And I think the reason this is so is you have to read the term health insurance in 33931 with the insurance code, with Title 20. If something is, we're not dealing with a situation where the legislature has given a statutory definition in this particular provision for health insurance. So the question I think you have to ask yourself here is MedPay coverage health insurance under the Arizona Insurance Code? And the answer to that is clearly no, it is not. MedPay is classified as vehicle insurance or casualty insurance under Title 20 of the Arizona Revised Statutes. And there's 50 years of case law from this court and the Supreme Court that recognize that fact. There's the Caballero case, there's the Backus case, there's the Aetna Life case, it's in our briefing, that recognize and say that what is at issue in those opinions is a medical payments clause and a medical payments provision under an automobile insurance contract. Now,
what those don't quite say, though, and that may be your next sentence, is that that's different than health insurance.
That is correct. Yes, that is correct. And that was going to be my next sentence, actually. The court did not say, to be sure, that MedPay is not health insurance, but the court did recognize MedPay as casualty insurance, and it wasn't really a debatable point in those cases. The insurance contract at issue was an automobile insurance contract in each of those cases. It was not a health insurance contract. And so the court recognized, okay, this is casualty insurance we're dealing with. And so what you have are sort of two circles. Imagine a Venn diagram. You have health insurance on one side, you have casualty insurance on the other side. There's no overlap between those two. Casualty and health insurance do not intersect with one another. They insure different risks, the underwriting is different, so on and so forth.
Couldn't someone looking to seek health insurance without any federal regulations or any other overlays, statutory overlay, just say, I want to protect against accidents. I'm going to get a homeowner's policy in case I get injured at home, and I'm going to get an auto policy to insure in case I'm injured in a car accident. That's the only health insurance I'm going to have. Is that a kind of a common sense interpretation of the term health insurance, that I've at least insured my health to the extent I'm injured either at home or in an automobile?
I think that's an odd, to say that I have health insurance because I have MedPay coverage on my car, with all due respect, I think is an odd way to phrase it. If I say I have health insurance, I have, in sort of just common vernacular, I'm insuring against any sort of risk to my body. I'm insuring against cancer, against any communicable diseases, against any sort of for any sort of potential illness.
I could get catastrophic that's only insuring for.
Oh, sure, yes.
Or I could just insure for hospital stays. I mean, you could,
sure.
And arguably that's, it does seem like a bit of a stretch to me, but it's at least arguable, perhaps, that I'm getting some form of health insurance by insuring against bodily injuries that result from an accident.
I think, though, at the end of the day, there's a certain degree of common sense we have to apply in construing a statute, and it's that, and this is why we go to the ordinary and common usage of a particular phrase. I would submit that the ordinary and common usage of health insurance is not a medical payments policy that only covers against an accident if I am in the particular vehicle that is insured. If I'm in someone else's vehicle, I'm not covered. If I'm in a vehicle that's not subject to the MedPay policy, I'm not covered. I think I don't think it would comport with common sense to say that by virtue of having MedPay coverage on one vehicle, you have health insurance as ordinary people would use that term.
Well, but when we look to the statutes, Title 20 doesn't really help us very much. It has a definition of health insurance that, best I can tell, doesn't apply here, and it doesn't contain a broad definition of health insurance. And by broad, I mean generally applicable definition.
You have, though, what the statute seems to say is that there's three different I'm actually digging into this in another matter, the history of health insurance regulation and such. And there are three broad types of health insurers out there in terms of licensing. You have disability insurers, you have healthcare services organizations, and you have service corporations. Whatever policies are issued by those entities, we would submit falls within is what we ordinary people would regard as health insurance. And what's missing from any discussion of disability insurance or health insurance in Title 20 is medical payments coverage. That's what's utterly missing from that. And that's what, frankly, that's why we believe when you construe health insurance in 33931 with how Title 20 deals with the subject, you can't have a situation where medical payments coverage falls within health insurance for one, but is not within the bailiwick of health insurance in the other, within Title 20. And so, like I say, we believe the trial court simply erred by agreeing with Farmers that MedPay is health insurance. I want to briefly discuss this new argument that Farmers is making on appeal, that MedPay is actually something called health insurance motorist coverage. This is a term that simply does not exist anywhere else in the law, and frankly anywhere else in the universe. You will not find the term health insurance motorist coverage anywhere in the Arizona revised statutes, in Title 20 or anywhere. You will not find it on the Department of Insurance website or in the Arizona Administrative Code. And frankly, if you even just do a Google search, you will not find this term anywhere out there. No marketing materials from insurance companies, nothing. I think what happened here is that Farmers has invented an exclusion to fit to what they believe fits MedPay that just simply does not exist. And we trace the history of the lien statute to show you why that is. The two exceptions that we're talking about were enacted 16 years apart: health insurance in 1988, UM/UIM coverage in 2004. What Farmers did, though, was split the 2004 amendment, which added uninsured and underinsured motorist coverage as defined in Section 20-25901. Farmers split the term to basically create this modifier called motorist coverage that doesn't mean anything. That doesn't mean anything in Title 20 and doesn't mean anything in any other context. You will not find the term motorist coverage just by itself in the insurance code or anywhere else in the Arizona revised statutes. Motorist coverage refers necessarily to uninsured and underinsured motorist coverage. That's why the acronym for that is UM/UIM, uninsured motorist, underinsured motorist. And so what Farmers does is improperly split the statutory language and then apply motorist coverage to the prior exclusion, health insurance. Well, there's two reasons we believe that's wrong. Number one, that would actually eviscerate the legislature's intent by making ordinary health insurance claims subject to a healthcare provider's lien. The exclusion would, under Farmers' view, be health insurance motorist coverage, not health insurance. But more than that, as a basic matter of statutory construction, the motorist coverage here does not modify health insurance. It just modifies it to the extent you call it a modifier at all. We would submit it's a self-contained phrase: uninsured motorist coverage, underinsured motorist coverage. I'll reserve my time here in just a moment, but the key point I think we have to come back to is as we go through this sort of what we believe is the contorted view of Farmers' new argument about health insurance motorist coverage, that only underscores the central point here, which is that if the legislature intended to exclude medical payments coverage, that's what it would have done. It would have done so using those three simple words. That's not what happened here, and that's why we believe the court needs to reverse the judgment. I'll reserve unless the panel have any questions for me.
Thank you.
Good morning, Your Honor. Brad Jardine on behalf of Farmers Insurance Company. The argument with respect to the health insurance motorist coverage was emphasized in the response brief for purposes of providing a grammatical exclamation point to the way that the statute is written, not to create a different coverage. And counsel's effort to do that is, at best, misleading. We have not waived any arguments, and in fact, it is my position before you today that in fact, MedPay coverage is health insurance. That's exactly what it meant, because it is not susceptible to any other definition. We are here, and I agree with counsel absolutely, that we are here because this is a matter of first impression in Arizona. We do not have guidance from the legislature on particular definitions. And we argued this motion to the trial court, and we believe the trial court correctly and thoughtfully thought about the issues before making her decision to grant the motion to dismiss. It is important.
Are you saying the exception is for health insurance as defined in Section 2259?
I am. That's exactly what it says.
But where is there a definition in that section about what health insurance is? That seems kind of nonsensical to say as defined there and then there's no definition, whereas there is a definition for the underinsured and insured motorist coverage.
In sections A and B, you're absolutely right. It's very interesting because we are healing, and in fact, counsel for Dignity and I, in some respects, are dealing with the same problem. We're dealing with a situation where a legislature did not provide the definitions that we wish it had. We have a grammatical construction of a lien statute which doesn't have any punctuation in it. You know this because you've read it. And doesn't seem to differentiate between the two. In subsection J of 2259.01, we have a reference to motorist health insurance payments, but we do not have any definition within that. And what's interesting about that and difficult from my viewpoint.
MedPay payments in 259, not health insurance payments, or do you mean health insurance payments?
I meant health insurance payments, and it is our position that MedPay is health insurance payments.
I understand that. What we're trying to do is to figure out why that should be.
You know, I wish I could explain to this court what happened sequentially and historically in the legislature over a number of years as it dealt with these particular lien statutes. I can't do that. I'm not clairvoyant, and I don't have the ability to do that.
Don't we know that health insurance was in there before the underinsured and uninsured motorist coverage? So would your position have been that that health insurance without the underinsured or uninsured motorist coverage, that would have included a MedPay?
At the time, it would have. At the time, here's the situation. This court is faced with a situation dealing with the current statute as it reads, and it's difficult to determine how to read it grammatically. It is what it is, and I can't change it. Counsel for Dignity can't change it, and we're stuck with what it is and trying to then apply rules of statutory construction, which are you look at the plain language of the statute, and if it's susceptible to a rational, reasonable, plain interpretation, that's what we run with, because we don't have any other choice. And the fact that sequentially it happens to have occurred in a sequence that seems unusual, the problem in essence for this court, and I don't mean to obviously do that, is that this court is charged with the responsibility of determining under the statute as it exists, is MedPay included within it? And if
Can I ask you though, would it be inaccurate for us to read the statute, or would you disagree with reading the statute to put in parentheses a 1 in front of health insurance and then a parentheses 2 in front of underinsured and uninsured motorist coverage?
Not the way it's grammatically written.
But wouldn't that be so? You're essentially suggesting that there's an ambiguity and that you can't necessarily read it that way. If you read it that way with a 1 and a 2 in front of underinsured and uninsured, then that would be inconsistent with the position that you're taking?
I think that would be inconsistent with the position that I have to take,
okay,
and which grammatically appears before this court.
If what I'm coming to then is that you're suggesting there's an ambiguity in the way it's written, and if we then look to the chronology of how the statute came about, where there was a separate exception for health insurance, doesn't it make sense for us to read in that parentheses 1 health insurance, and now the legislature has added something else underinsured and uninsured.
The reason I respectfully disagree is because I don't think there's an ambiguity in it. I think that it was intended to be as written. Let me tell you why. We're dealing here with three separate coverages. One is the medical payments coverage, one is underinsured, and one is uninsured. Both of those have some common, or actually all of them have common denominators to them. They are all coverages which are personal. They are all coverages which are completely optional. Anybody can purchase them or not in any amount you wish. And what I believe, I wish I had something I could tell you about this, but we're dealing with an Arizona scheme that is unique. We don't have anywhere else to look. And so what I think we're dealing with here is a situation where the legislator said, okay, you policyholders have purchased, you've elected to purchase a policy provision coverage that provides for med pay to cover yourself in the event of an injury. You've covered yourself by purchasing uninsured and underinsured in whatever limits you decide to do that, compliant with the statutory scheme. And if you do that, policyholder, we are going to reward you by then applying the lien statute to that to let you have as much as possible of the money you've paid for those coverages. Because that is a policy that seems to be consistent with the Arizona approach, at least to UM and UIM in cases, if not legislative matters.
Counsel, I completely understand that argument if one of two things happened, neither of which happened. 33931 used MedPay instead of health insurance, or 225901 defined health insurance to include MedPay. Now, I don't see that in either of those statutes.
You're right. Those words are not there. And I agree with you. I wish that the definitions were there, but they're not. But here's the next question. What else could that mean other than medical payments coverage?
It could mean health insurance.
Right.
It could mean health insurance, but it also could mean medical payments coverage because it applies precisely to the circumstances of this case.
Wouldn't you then be reading it to only be health insurance as defined in 2259? Wouldn't that exempt, or wouldn't that then take out from under that umbrella normal health insurance that somebody had, and that you would no longer have an exception for regular health insurance if you're suggesting that it's just health insurance as defined in section 2259? Aren't you reading out health insurance in other contexts?
I'm not necessarily, and the reason why is because I read it as referenced in 2259.
But then you're saying health insurance otherwise is not accepted.
I'm reading health insurance as applied within 225901. I don't have any choice except to read it the way it's written.
But a hospital can get a lien against insurance proceeds, health insurance proceeds in other contexts that don't involve a car accident? Is that?
Yes, it can and does.
Although, to the extent that happens, that's not in the record before us.
That's true. That's not the issue before you. I agree. This is a basic conundrum, and it's what's a curious situation here, and this is, I guess, the final point I wish to make, because you are obviously really familiar with the issue, and I appreciate so much the care and time you've taken to immerse yourself in it, because although it's a simple, straightforward statutory construction case, it is a tricky case and a difficult case to analyze accurately, particularly given the fundamental premise, which is when you look at a statute, you first look at plain language. If it means what it says and it's susceptible to a clear meaning, that's what we run with, even if the historical perplexities don't make sense. And if there is a fix that needs to be rendered here, the fix has to be made by the legislature, not this court. I don't have any additional points to make. Actually, I do, but that's enough. Thank you.
I will necessarily be brief because I have less than 2 minutes to go. I think Counsel for Farmers is quite right that the legislature needs to fix this issue, but it runs in the other direction from what Farmers is saying. If Farmers wishes to have MedPay coverage excluded from the lien statute, the Farmers has to run a bill at the legislature to do that. The burden is on them at that point to do that. The court can't the Farmers sort of can't induce the court to go through these contortions to try to fit MedPay coverage into a box where it clearly does not fit, which is health insurance. I think, Judge Katani, I think you analyzed the grammatical structure of the exclusion absolutely correct. You would put paren 1 in front of health insurance and paren 2 in front of uninsured and underinsured motorist coverage as defined by 20-25901. This is perfectly consistent with the history of the statute. That's how it came about. And again, I think I've said this before, but 20-259.01 does not define health insurance. It does not do that. And so even under Farmers' view, it cannot work because there is no definition for health insurance in that statute. And, and Farmers is giving these policy reasons why the legislature might want to exclude MedPay from the scope of the lien statute. If that's all true, why didn't the legislature simply put the 3 words in the statute? Why isn't medical payments coverage there if that's all true? The legislature knows how to talk about MedPay.
What is different about a med payment under an auto insurance policy than a health insurance? Isn't it the same thing? The person's injured, is in a hospital, gets money to pay for the hospital. If you have health insurance, injured, go to the hospital. You can't get a lien against health insurance, but you can get a lien against the auto policy that does the exact same thing.
Well, I don't know that I would agree that it does the same thing because, with health insurance, and I'm out of time, so I'll keep it brief. With health insurance, you have all sorts of, there's the issue of whether you're in network or out of network. You may or may not be covered for a particular service. There's all sorts of issues there. And so, I would submit that I'm not sure it is the same thing, just because with MedPay coverage, the concept of it is it's a no-fault coverage. You don't have to look to whether someone is at fault for an accident. You don't have to look to whether a hospital is in network or out of network.
But you have with health insurance, they don't usually ask who broke your arm.
Well, they don't, but the problem you sometimes run into with health insurance is that a hospital or a provider may be out of network. You run into sort of other medical reimbursement issues that are far, far too complicated to get into here, quite honestly. So.
All right. Thank you both for your argument.
Thank you.
We appreciate it. We will take this matter under advisement and issue a decision in due course. And with that, we are adjourned.